Good morning, good afternoon, good evening, yWhales. My name is Siva Avvaru, Managing Director of yWhales Solutions, and I'm joined by my good friend and board member, Sue Marks. Today, we have a great guest from Jayaram Law, Vivek Jayaram. Excited to dive into technology and implications from a legal perspective, and how the legal environment is trying to keep pace with this rapid innovation cycles right now that we've seen post COVID, especially. Vivek, what is some of the biggest topics right now that you're being considered from clients that are coming to you, especially around when we think about AI and ChatGPT and these large language models?
Yeah, well, nice to see you, Shiva, and Sue. Great to be here with you today. I guess, I wish I had a really clever, unique, original answer for this question. But if I'm being completely honest here, over the last, I would say, really 8 to 12 months, we have been increasingly inundated with questions around AI. And I think what started as just sort of some drips here and there, little questions on the fringe of businesses and maybe some interesting startup ideas, have very quickly transformed into large digital transformation type of projects for some of the world's largest companies. I've been practicing law about 20 years, been alive for 44, and I feel like I've never seen a 12-month period where a specific technology has sort of propelled itself to the forefront of both the business and sort of cultural communities globally so quickly. So I'm excited to talk about that today.
Vivek, when we were talking earlier, you mentioned kind of in from late 2021, early 22, lots of startups, et cetera. And that kind of hype cycle, now the big brands are coming in and they're taking over. Can you talk a little bit about that?
Yeah, for sure. So, I'll give you just a little bit of one of my most favorite things about, I guess if we're calling it Web3 or like blockchain or AI, I would put all these things in the bucket of just new and emerging technologies, right? And I think one of the most interesting things about Web3 for me is that, it's so new and it's so early that it's interesting to look at everybody's sort of entry point to it. Right. And so I'll just tell you for a minute how I kind of got into it, and then I'll talk a little bit about the last couple of years, So I spent the first 5 years of my career working in big law, doing a lot of corporate and IP work, good place to get trained, made some good friends, but ultimately was not something that I wanted to sort of go down the partner path and stay with, for decades. And so I started this firm back in 2009, really with a singular idea to have a law firm that is built from day one for creatives, entrepreneurs, and creative brands. And so from the very beginning, we had this real focus on new technologies, emerging technologies. And we were focused really on three kind of industries, which are fashion, art, and tech, right? And tech is such a weird thing to think of as an industry now because everything is tech enabled. And if you're not tech enabled, you're probably falling behind. But at the time, it really was sort of a growing industry of creatives who were making things with software, right? And, say 15, 16 years ago. And so it was, I think for the first 10 years or so, I had these fashion and art clients kind of on the one hand, and then I had these tech founders on the other hand, and they were just kind of growing and bubbling up sort of in unison, but also kind of in parallel. And then in 2019, towards the end of the year, I'll never forget it. I had an artist client of mine text me some artwork he was working on. And I said, "Oh, cool, digital art." And he said, "Yeah." He goes, "They're calling these NFTs." And I had never heard that term before. I was familiar with blockchain technology. We had done some ICO work, although not a ton, but back in 16, 17. So I was familiar with cryptocurrencies generally and blockchain, but I had never heard this term, NFT. So I remember Googling it, and, it was buried somewhere, third, fourth page, something like that. I read a little bit about it. And then lo and behold, a few months later, I was approached by another client of mine who had a brick and mortar art gallery up in Palm Beach. And she told me she was going to be shuttering the gallery in favor of working with one specific artist to create an NFT project. I was surprised. She had a relatively thriving gallery that had been, over on Worth Avenue for a while. And, but, I thought it was interesting. So we were helping her build the project, with all the contracts and the privacy policies, terms of use. And back then there were really not many, best practices for NFTs. So we were just kind of doing it the way we thought was like the best way to do it. And lo and behold, that project dropped early in the pandemic, and it was called the Bungie Project, which some of you may have heard of. And at the time that dropped, it was the, most valuable, highest selling NFT project, in history at that time. And so that kind of catapulted, myself and the firm into this NFT world. And sure, I've been working for decades with contemporary artists and in fashion and with tech founders, but this specific on-chain kind of space where people were creating digital art, which sort of has now morphed into a little bit of generative AI and things like that, was really interesting. And artists gravitated to it because it allowed them to collect resale royalties for the first time ever, even though, people have been advocating to the NEA and others on Capitol Hill for decades to get something like that, so that creators can earn money on the resale of their artworks. And then also it helped curb counterfeiting, because if all the transactions are taking place on chain, so to speak, on the blockchain, we can verify the authenticity of these works, right? So it was something that was very appealing, this technology, to creative people, right? And so in 2020 and 21, as Sue, you mentioned a minute ago, and I would say even the first half of 22, we saw an explosion of these kinds of NFT projects. I mean, if I'm being, I don't have a number in front of me, but it felt like every day and certainly every week we were launching a new project, and it was very exciting. It was great to see this sort of real potpourri of creativity and like people really experimenting in very interesting ways. Most of those projects failed, right? They did. But I still think every single one of them added to the sort of fabric of what is going on in blockchain today, because it showed us, a little bit of what might work. It showed us a little bit of what might not work. And so collectively, I think that the community moved forward. A lot of that VC funding, dried up last year, and everybody knows that. And that is also quite typical in these venture markets and in these cycles, right? But I think, to your point, what has been really interesting and something that I did not expect, at least personally, was that over the last year, really around the time that I would say a lot of these venture markets sort of, went a little bit cold, we saw a number of large public companies and brands really start to experiment and implement and execute really interesting projects on chain for their audiences and consumers, right? And so I think there was really two phases of that I've seen in the last year. I think phase one was, I would say, Q3 and 4 of last year. And at least in my mind, the way I kind of look at it, it all kind of, it hit a bit of a fever pitch with Starbucks back in December when they launched their, what I think most people would say is a pretty successful NFT membership and loyalty project. And I can say in the last quarter, we haven't launched many startup NFT projects, a couple, and I think a couple that are pretty interesting, but we have been talking to a lot of brands about how they can engage in their community in, on chain, through various kind of membership and loyalty and other kinds of initiatives. And I think that's sort of like how the brands are looking at it. And I think from like the technology standpoint, we're also now working with a lot of founders who are trying to engineer and create products that allow these brands and companies to deliver an on-chain, program that has a bit of like a Web2 interface, and Web2 UX, right? So I think, we've kind of come a little bit full circle and have decided, I think, okay, we know that we're going to get there, but maybe we got to get there a little bit more, with a little bit more, in a little bit more measured of a way, right? And sort of, let the sort of mainstream, come as they are, right? And so that's what I think is sort of going on right now.
You hit on a really good point there that I don't think is really being talked about right now. When we think about the Web3 space today, it's April of 2023. A lot from a retail perspective, we are in a crypto winter, right? We are in a pretty rough bear market. Although, we just had some nice price inflection points here with Ethereum and Bitcoin, but a lot of retail, the hype, the frenzy, especially around NFTs for the past 2 years, is not where it was in its peak. I would say right after post COVID and maybe those 6 months post COVID, but we had a lot of innovators attempt with projects and really push the boundaries and the envelopes of what these Web3 capabilities could bring potentially to market, right? And I think to your point, you need those failures, so to speak, to set. I think you this point will resonate you, especially from a legalese perspective. You need someone to establish precedents, right? So that you know how to navigate and kind of chart moving forward. And I think that's what we saw. Last year, I think a handful of major brands were pretty successful with their Web3 initiatives. Nike generated $186 million in revenue in 2022 alone. That's pretty successful, right? It's probably to date, that's probably the most successful enterprise Web3 NFT project. $186 million is a blue ocean strategy. It's the net new revenue stream that they just tapped, right, with existing customers. Interesting, though, that you are seeing a lot of major brands double down in this space. And that's what we're seeing from an advisory perspective as well. Last year, you had a lot of brands kind of seeing who in their industries were going to be the first ones to kind of like plant a flagpole, so to speak, and, say, hey, we are going to explore Web3. This is our strategy. We'll throw it at the proverbial wall, see if it sticks. If it doesn't, we tried, right? And maybe we can write it off. But this year, we're seeing a lot of major brands start to really establish and look at the underlying technology and understand, where does blockchain potentially amplify my business? Where does NFTs potentially empower my customer acquisition strategies? Where does my metaverse potentially promote, better customer engagement? Blah, 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 right? And I think a big thing that came out last year around trademarks and IP, especially, those discussions started to bubble up here, especially on the secondary market with NFTs. Who is the rightful owner, royalty rights, all that good stuff. One thing that I was speaking with a Fortune 2000 a couple of weeks ago, and a big thing that happened last year, especially with a lot of brands that were deploying NFT projects via these native, NFT platforms, they just, threw digital assets up there, deployed them, went on chain. They wanted to see what happened, but then they realized they actually didn't own the IP of what they were deploying because they were deploying it via another platform. And so they absolved themselves of a lot of those rights. And so now what we're seeing, I believe in Q1 of this year, was some of the most highest volume of trademarks filings for NFTs and digital asset IP. I think you're starting to see a lot of enterprises start to be a lot more strategic and thinking about, hey, if we want to explore Web3, we have to ensure that legally we own what we're going to deploy. And, from a revenue perspective and from a loyalty perspective and from a rights perspective, when can we continue to use this stuff as we start to expand? Are you seeing a lot of that from your clients in terms of as they start to be a little bit more thoughtful in terms of their digital strategies, especially around NFTs, metaverse, even AI, so to speak, how they're actually thinking of it from a legal perspective first before they actually dive, both feet into the proverbial water, so to speak?
Yeah, that's a great question. So this is a great time to be an IP lawyer. It is. It's very interesting. It's very exciting, and it's changing very quickly. It just reminds me of some of my early days of practice when we were dealing with a lot of the fallout from Napster and LimeWire and stuff like that. I thought, some of the stuff we're seeing now is really, really otherworldly, and some things you'd never thought you would really see in your life, right? But so to answer your question, I would say this: the thing about IP when it comes to things like NFTs on chain, right? People were flummoxed by this. People were like, what do we do? What does this all mean? How do we retain rights, right? I have a very specific point of view on that bucket of IP. And there's another one we'll talk about. So there's really two things I want to talk about. So the first is really, this NFT IP that is minted and then distributed on chain, right? For me, I found that IP in this area was very logical because it handled in much the same way that contemporary art has been handled, or visual art generally has been handled, right? So I am somebody who is of the view that our Copyright Act and our trademark laws are perfectly fine as is to address things like minting an NFT, and then selling them on chain, and then people reselling them, and so on and so forth, right? I mean, that to me, that is no different than a Basquiat or a Warhol being, painted and sold at Sotheby's or in a gallery in Soho or anything like that, right? And I have yet to really hear of why this is any different. Now, that said, most people who were playing in this space are not coming from the contemporary art world. So they may see some of this stuff and be like, before I put this stuff online, or, oh my gosh, somebody can right click save and all this kind of stuff. Well, yeah, you can also, stroll through a museum and buy a poster of all the works you just saw in the gift shop, right? It doesn't mean you own the intellectual property of that painting, right? So I think there's a lot of red herrings in this area. But I think when it comes to intellectual property, if a creator is making an NFT, it doesn't matter which chain they're minting on and who's buying it and who's selling it. Like, unless they willfully and knowingly, in the terms of use, like assign that IP to whoever's buying it, right? They own it. Now, Bored Ape was interesting, and everything that sort of followed Bored Ape was interesting from an IP standpoint, because Bored Ape, Yuga Labs decided, we're going to let the people who bought the apes, we're going to let them commercialize the IP, right? Now that is interesting, but that doesn't change the law in any way, right? We've had the freedom to contract and enter into licensing agreements, as long as this country has been around, right? So I think that, it's a super interesting area, and we could talk about, IP on the blockchain all day. But I think what it's important to know, and why creators should feel some level of comfort, is that, like, you're an artist or you're a creator, right? And unless you are deciding in writing to give that IP to somebody, you own it, right? And that's how sort of Congress decided to craft the Copyright Act, I think, appropriately, and that's sort of how it applies today. However, Shiva, you ask a very good question, because number 2 is a circus right now in IP, which is artificial intelligence, right? And so, you see artists and creators and brands and everybody using tools like Midjourney, Synthesia, DALL-E, right? These are amazing, amazing tools. I mean, they are. If you mess around with it yourself, I do it all, on the weekends. I'll even sit around with my kids sometimes and just see what we can make on Midjourney, and stuff like that. It's cool, right? But what is very interesting there, and I don't have an answer for it, is what is going to happen to copyright, right? Because I think many of us, and I was proven wrong for one, figured that, okay, when somebody like a Chris Castanova, who is an AI artist and scientist, who is sort of one of the few sort of litigants who is kind of leading the charge on the creator side to try to get some clarity from the U.S. Copyright Office. She filed an application for essentially a comic book that she made, and as many comic books have, there were images and then there was text, right? And after bore you the whole back and forth between her and her attorneys and the Copyright Office, but the long and short of it is, okay, the Copyright Office is willing to give some protection for the text that was created by an AI tool that tells the story of her, it's called Zarya of the Dawn, of her comic book. But they first granted and then reversed themselves and said, we're not going to grant you protection over those images of the comic book characters that are in Zarya of the Dawn, because you have seemed to have disclosed to us that this was made by an AI tool. It was made by artificial intelligence. It was made by a machine. And since our Copyright Act and our federal statutes generally are passed by Congress to govern the conduct of human beings, right? We can't now start giving protection to things that are made by non-human beings, right? And that sort of goes to what's known as like the human authorship requirement under the Copyright Act, right? So this is a fascinating conundrum and one that has not been resolved. I still personally believe that here this is where I don't think on the blockchain issue, but here in IP, I do think we are going to need some guidance from the copyright, probably from Congress eventually, or there either going to have to be an amendment of the Copyright Act that specifically addresses what you do with AI works, or we are going to have what so often happens, and it's starting to kind of go in this direction, although, don't know where it's going to end up next 2 years or so, but I think you're going to get some more of these agency actions, right? People like Castanova and others who are going to be fighting with the Copyright Office and saying, what are you talking about? I can't get protection for this stuff, right? I've got two pretty well-known clients right now who are going through this battle right now with the Copyright Office. And so we'll see what happens. But ultimately, it's going to probably take some of these creators to file lawsuits in federal court saying, hey, I need a declaration that I own this work, right? And it's going to bubble up. And as so often happens, you'll probably end up going through the appellate courts for a couple of years. And at some point, there will probably be what is called a circuit split, right? Which is you've got 11 courts of appeals in the United States. Some of them will say it's a machine, no protection. And some of them might say, all right, this is just innovative and cool. We're going to grant you protection, right? And when you have those circuit splits, that's when the U.S. Supreme Court will oftentimes jump in and sort of, give the sort of final word on it. But at some point in this thing, right, that we're talking about the judicial branch, at some point the legislature might just jump in and say, okay, you know what? People are spending a lot of time and a lot of money and a lot of resources, on the federal level to try to figure this out. Maybe we should just pass a law that clarifies this, right? So, that's oftentimes how new technology is treated, and I'm kind of starting to see it going in that direction.
Yeah, that's interesting. And to your last point, we always wait for the law, but the law is always, the last to catch up, right? It can never keep
waiting for the law is like waiting for Godot, I'll tell you that.
Right. I mean, hey, we're still waiting about, from the SEC, what a security means in the world of crypto, right? But yeah. I mean, I'm just soaking up everything you just said, and I think for a lot of our listeners, especially a lot of traditional executives that haven't dove into this, but are probably posturing especially from an enterprise or from a brand perspective. I'm going to run through a quick exercise with you here. We always do this in consulting, and you probably do this within your law firms. If I'm a major brand. And let's say I had the directive to my CMO and my marketing team that, hey, I need to spin up some quick digital assets really quickly. We need to push them out there. They're going to be used for some sort of marketing channel, what have you. And my team, unbeknownst to me, uses Midjourney or DALL-E and generates this amazing campaign. And they're just beautiful images. I mean, I think we've been seeing them all over LinkedIn and Facebook and Instagram, some of these modern, human civilizations that have been modernized, and, people are using them as part of their marketing campaigns. But to your point, that verbiage, human authorship, that has not been authored by a human, that has been authored by an AI. And now if we take that one step further, we have people creating entire websites, creating entire IP within ChatGPT. And if you go on WeFunder right now, you can go and find startups of people that have built, really quick, digital IP of really quick, websites that ChatGPT has completely authored the code. And now they are selling that, as, an acquisition or actual, a business to be acquired. And, as we know in M&A, IP validation and IP ownership and defensibility is a huge topic. So how does that start to, I guess we don't have any, legal guidance just yet because there is no legal statute that has been, instantiated here. But, if I'm going to go and acquire, a company that has a really quick capability and it's been completely built by AI, what is my risk of actually owning that IP because that concept of human authorship is not there?
Yeah. Fantastic question. And I love that you brought in the M&A angle too, because that is really where, the rubber meets the road when it comes to some of the stuff around like diligence and things like that, right? So I'm having this exact conversation, Shiva, with a number of brands and companies that we all know, right? So this is exactly the question that's getting asked in those boardrooms, in the general counsel's office, in the C-suite, right? And in these creative meetings. And so here's what I'd say. I'm telling clients, listen, if you want to make stuff like from an HR standpoint, internally for your employees, for culture, for, your intranet and like your, stuff internally, go for it. Knock yourself out of Midjourney, Dolly, all these tools, right? I think when it comes to, though, your actual question, which was, well, what if I want to make creative assets to like share with the world, right? Maybe put in a television commercial, maybe put on my YouTube channel, maybe, act as like a new sort of brand, right? Or a new look and feel for the brand or whatever. I'm almost shocked to have to tell you, like, there's not protection for that, right? So if you are going to, redesign the golden arches or the Nike swoosh and rebrand and use some, because there are some big brands that are like, wow, the possibilities here are quite like extensive. So maybe we can do a rebrand with Midjourney. This is really cool, right? Well, yeah, it is really cool. But guess what? Most of your, assets that you're going to be creating are not going to necessarily be, able to be sort of, protected from a copyright standpoint, right? Now, if you create a new logo or something like that, like from a trademark standpoint, that might be okay, right? But if you're creating all these images, right, you want to make, just to share, for, like you said, a landing page for your website, right? Well, if you make that beautiful image as a landing page for your website, guess what? Your competitor can use it tomorrow. Right. So like, and that's kind of terrifying. And that's not at all what you learn, right? When you're talking about like creative assets and things like that, right? What makes a creative asset sometimes so special and unique is that it is special and unique and nobody else can use it. Right. So that is exactly the question that's going on right now. And so, people are dealing with it in many different ways, right? I mean, this is like a total extreme. You'll get what I'm trying to say by giving this example, but I have one very close friend, artist, a very well-known artist globally, who is making AI works that he prints out and then he paints them. And it's like, okay, well then you got protection, right? You can protect the painting, right? So, there's that, right? Or there are folks who create these works on Midjourney, but then they just use them as a reference point, and then they go into like whatever tools they typically use digitally, right? Or they might use like their hand to make certain, aspects of it. If, their creative team do things a little bit more traditionally, right? To try to get the protection. But, the long and short of it is, to your point, if you make this beautiful civilization, montage on Midjourney that you think would just be a very impactful landing page for your website or your e-commerce store or something like that, it might still serve the function and look cool. And by the way, it's not illegal, right? It's completely legal to do it. The concern is if you don't own it, who else is going to, be able to use it? And that point, the who else is going to be able to use it is exactly why a buyer in diligence is going to say, well, what are we really buying here if none of this stuff is like exclusive and unique to the seller, right? And so, I haven't, it's a great question. I mean, we're in diligence in a few deals right now, and I don't know that any of them are going to have this exact AI component to it, but I guarantee you by the end of the year, we'll have had to deal with this issue in the M&A context, which I think is a pretty interesting one.
So Vivek, when you think about business process patents that have been given for kind of rules-based automation, which some would argue AI is a little bit like, yes, it's a large language model, but the if this then that, the old rule base that is still used. So when do you cross the, well, we can no longer trademark it because we have trademarked things that have used rules based, whether it's a business process or whether I'm on Canva or Wix and they've got logo generators. They ask me 10 questions, which is like an if this, then that, and that generates a logo. So right. Lots of thorny issues.
Yes, no, those are great points too. And I think like, people will also say, well, gosh, what about sampling of music, which is like basically been the majority of the record industry for the last 30 years. Like how is that, when I go grab a sample off of any of these tools and incorporate it and I rap over it, like I could have a huge worldwide hit and own all the IP in it. How is that possible? Right. And these are all the arguments that I think people make. I think that the thing that personally, I don't know this, but I do think, Sue, the thing that I think is really bothering the Copyright Office, I assume, is that it's not as if-then-y as the things that are out there. It is. I understand completely what you're saying, and I think that's a very smart. That would be a very smart argument to make to the Copyright Office, right? These are exactly the things we should be arguing. I think what's troubling them is that you put in a prompt and you literally have no clue what's coming out, right? And you could say the same for some of these generators, I suppose. And there are a lot of analogies, but I think ultimately they're saying, but to your point, I will say this, and I should stand a little corrected, and I'm glad that you brought this up. In the last decision, the last Castanova decision, which is in March, that kind of stripped them of the copyright that they had initially granted, the Copyright Office did say, and I should say this, and that's why I think that's a really acute comment you made. The Copyright Office did say specifically that, listen, we're not making a general rule here. We're not going to make a general rule that all AI works are not protected. All we're saying is Castanova told us that this one is made by a machine, and that all they did was put in some prompts, and they disclosed the prompt, and here's the result, right? They did say, however, in the future, right, perhaps the prompt itself could be something so original and authored by a human, obviously, right? That you can get protection. And when I hear that, I think, Sue, that, okay, well then maybe prompt engineering, which has quickly become a professional calling, right? Those prompt engineers and the prompts they create might be protected a lot like source code, right? Which, if you just go back, 30 years, 40 years, 50 years, source code is actually protected in the same way that like poetry is protected. It's just a literary work. Wow. Right. So we might go full circle here where like this super futuristic AI thing is just like a poem, right? It's like a literary work. It's words on a page. Right. And I think what some folks are arguing is like, listen, these words on a page. I mean, if you look, you guys are, probably have seen this a million times on LinkedIn and elsewhere. You see when all these folks are sharing the prompts that they're using to create certain images. And it is far afield from the prompts that were being used 90 days ago, 120 days ago. Yeah. People are really getting in there. I mean, the prompts that my kids and I use are like very basic, and then all of a sudden you see these people who are like really in there. And so I think you're onto something for sure, because I do think at some point, somebody, the Copyright Office is going to look at this and be like, hey, listen, like nobody, like the reason this work is this is because this person put all this over here, and that takes some creativity, and that certainly takes human authorship, right? So I think this conundrum is going right down the road that I think we're all watching it go down the road, knowing it's going down this road, but we just don't know like what the outcome is going to be.
Yeah. Well, and there's probably another layer there that, I can't imagine copyright or, anyone that doesn't understand technology really has an understanding to be able to apply something like this. But, when you think of prompt engineering and prompts, let's say prompt is a unique asset, right? That is you created the prompt. So I don't know if there's an argument there that human authorship of the prompt is a safeguardable asset. But when you think about AI, large language models, let's use GPT again, ChatGPT, it's essentially, this is a very bad analogy, but, in essence, think of a centralized database that multiple people are accessing, right? Now you have a large language model that, millions of people are accessing from a web front end. If I put in a prompt, and let's say my prompt is a unique IP, and let's say it's been registered, all that stuff, where we're 5 years in the future, and Sue puts in a prompt that is very similar, but not to the exact degree, and it doesn't indicate any sort of infringement, there is nothing preventing us from, the LLM, the large language model, actually using its own internal processes and logic and all that good stuff, spitting out an output that is very similar in nature. So now I have my unique IP prompt, and Sue has her general prompt, and the output of the LLM, is very similar in nature. And now there might be some argument to say that, hey, Sue, you infringed on my on my IP, my trademark, because you generated this, and my prompt I can prove can also generate this. That's an interesting leg of potential illegal landscape. Maybe in the future that I don't even know if people are considering right now.
Yeah. So listen, think about it. Think about it this way. So today, so your listeners should know this. Today, don't even like, I'm almost encouraging clients, people who are just into this stuff, like to think of this in the same way that I was looking at like the blockchain stuff a few years ago. Don't think about it like nothing's changed in one way, which is this. When you're thinking about, am I breaking the law? Am I infringing on an art, on a work that's out there, right? The sole inquiry is, is A substantially similar to B? And we're only talking about outputs, Shiva, okay? Only outputs, right? So today, right, if you and Sue put in the exact same prompt on Midjourney, but for some reason it comes out with two separate things that are completely different from each other, totally fine today, right? In the future, though, what you're saying, and I think what you're saying is piggybacking on what I had previously said, right? I think what's an interesting issue / potential problem could be, what if you and Sue, so let's say you do have the protection over a prompt, okay? And let's say Sue puts in the exact same prompt, but her output creates something completely different because she's using a different software tool or something, right? And you then sue her for infringement based on your prompt. Well, but hold on, like what we created was completely different, right? So that is why this stuff I think has to be reconciled, because, you got to remember the whole point of the Copyright Act and the whole point of our intellectual property laws, what I think a lot of people lose sight of sometimes, the whole point of IP is to actually inspire innovation. Yeah. Right? It's not meant to like, hey, I can stop you. I can stop you. I can stop you. What it's supposed to do, and what the framers, thought of when they drafted the first sort of version of these things is, well, if we give our people these very robust rights, that will actually incentivize them to make more stuff. Right? And so that is sort of the beginnings of this like very rich, rich tradition of creation that we've had in the U.S. for, really hundreds of years now, right? Of innovation. So, and others might argue, well, that actually just, all it does is like, well, no, I think, there's been a lot of research and a lot written about this. And I do think that probably is, still true today. I do think that by granting people, rights and intellectual property, we are probably encouraging them to make more and to push the boundaries and make something even a little bit more creative, a little bit more innovative, solve some more problems. Because if you solve the problem, we're going to give you some upside that, we're going to reward you for, helping create these, solving these problems for our communities, right? So I think, I think that from an intellectual property standpoint, this AI conundrum must be solved from a copyright standpoint, at least, sooner rather than later, because as you said, like the brands want to use it. They already kind of are using it. They're just not quite sure how to like use it in the way they want to engage the public and the consumers.
Yeah. Yeah. Going back to our kind of earlier conversation with NFT and creatives and stuff, and I kind of want to take that lens again from a brand, a major company that's looking to get into this space. Based off of kind of how you've seen the market, and when I say market, I mean like the trademark market, I guess you could say, or the industry. It seems that now a lot of these brands, if they have a desire or they have identified that they will do something with a digital asset, digital IP, their initial reaction is to go and file for a trademark. Would you say that that's kind of like the overwhelming kind of standard right now, or precedent?
Yeah, I think we saw so trademarks are granted to parties who didn't just come up with the trademark, but who are using the trademark in commerce. Right? That's like the important thing, right? So if I just came up with the phrase, just do it, and then like I just tweeted it out, just do it. And then all of a sudden people made it into like, they started putting it on their, soccer shorts and then on their sneakers and then like on their hats. I can't really do anything about it, because when I tweeted, just do it, like, it was not in connection with any good or service. Right. So, we grant it based on use. Right. So if you are using, a trademark, so to speak, right, to create a digital asset, right? A digital asset is different from creating a apparel, or creating an automobile, or creating an airplane, right? Which are all different classes in which you would register the trademark. So really, the way to think of it is, that there is now this new kind of asset that is like a digital asset. And so if you're using your trademark, right, if you're, there's literally millions of trademarks, right? If you're using Nike, or, McDonald's, or yWhales, right? In connection with the minting of an NFT, the idea is, well, you should then now expand your existing portfolio to include this new class of goods and services, because this is sort of a new application of your already existing trademark. So that's why it's let's think of it super traditionally, right? Like, this is the same as when, let's say Nike decided to get into making sports equipment rather than sporting apparel, right? That would have required them to expand their trademarks into one additional new category. It's no longer just apparel. We're now doing equipment. Right. Maybe later they got into like making, I'm sure they've done like notebooks and things, and and so on and so forth. And now they're probably registered in dozens of classes domestically, and hundreds worldwide. Right. So that's like a way to think of it.
Where does he think that the legislation will end up around? Are NFTs securities? Why is digital art a security when, physical art isn't? If you could talk a little bit about where you see regulation going. Yeah.
This is a very hot button issue. I get it. And I know that like people are very passionate about it. I think that when we are talking about, collectibles, I guess would be the word that people use to describe this stuff. I look at those things like a Bored Ape or a CryptoPunk or a Doodles, I look at those no different than a piece of artwork. And I think we could probably talk, Sue, all day about whether, when I go to, an art gallery and I pay $2,000 for a painting from a hot new artist who just graduated from Yale MFA program, like, am I doing that with the expectation that that's going to increase in value and blah, 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 blah. But at the end of the day, the SEC has treated that transaction and every transaction like it, which are hundreds of thousands, if not millions of transactions a year, right? Treating that as not a purchase or a sale of securities, right? And so, I tend to think then that just because the artwork is being sold on a blockchain, or because the artwork is not, paint on a canvas or a sculpture, that it's it's source code and digital art, right? I don't think that from a security standpoint, it should be treated any differently. Because there are plenty of people who, collect artwork because it just, it moves them deeply and it means a lot to them. And they like living with it, and they like interacting with it. They like engaging with it. It has the power to transform, right? And a lot of people, believe that. And so, so that's how I feel about that. I think that there are other kinds of NFTs that certainly, that maybe give you, access to a certain revenue stream, or a certain, maybe you get a royalty or a some kind of, fee, or you get paid something for if something happens in the future, right? And that delivers an upside, and it's not really a collectible. It's just a token, as we're calling them, right? Like, it's just a token that, might have some future value. I do think that there are circumstances that are out there in which those have been, or are, and should probably be regulated by the SEC, for the primary purpose of just protecting, people like you and I who might get involved with some kind of transaction, or and so I hope, does that answer your question? I mean, I think that's how it will be treated, and it should be. I do think that we do need clearer guidance. I mean, I know the SEC has been, I've had moments where I've felt very good about the way that they're really digging in and trying to learn about this space, but then I'll just see some real heavy-handed indictment come down that doesn't seem to me like they're actually talking with the community to figure out what might be a workable rule. And so, I would, invite the SEC to talk with us more and more about learning about what's happening in the community, because I think everybody wants a very clear articulation of the rule. And and that might not have been the case a couple of years ago. I'll give them that, and I'll concede that. But right now, I think everybody just wants clarity. And I think whatever the clarity is and the guidance is, I think people will adhere to it. I just think that the longer you go in this sort of Howey test, crypto, blockchain, NFT gray area, it's just causing more consternation, as you're probably seeing.
Now, does intent matter at all? Let's say, I'm a creator and, I just decided out of the goodness of my heart, I wanted to drop, a 200-piece art collection because I just love art so much, and I dropped it. And I had no intent, and I dropped it for free. But on the secondary market, it just took off, right? And the acquirers of that asset, essentially turned it into a security. They bought it, they held it, they waited for it to appreciate, they sold it for some, net value appreciation. There's some profits there. But myself, as the original creator, I never had any intent to, make any revenue off of this. Now, would I potentially be, looked at for a slap on the wrist, because essentially that should have been, as the creator, that should have been registered as a security? Or how do I, where does the delineation become where the community takes my asset and runs with it versus I myself as the creator? I think you have a lot of independents and creatives that, maybe they just want, they sold it for an X price and that's all they wanted, but then the market just took off and ran with their collection. Does that play a role here at any point?
It's a good question. So here, if you remember, so the Howey test requires, right, that there's four things, right, in order to figure out if a transaction is a security, right? If there's an investment of money, expectation of profits, if that investment is in a common enterprise, and the profit comes from the efforts of a promoter or a third party, right? And so I think in this situation, I mean, when you're making art, right, I mean, and that artist sort of sells the first work. I mean, if you talk to artists, they're expecting to make, money from the work, and obviously they're making a living from it, right? But the person buying it, I mean, that's where I think the theory kind of, fumbles a little bit, right? Because it's of course, if a buyer is, many buyers, I wouldn't even argue with the fact that I'd say the majority of buyers might even be like, oh yeah, hot new artist, maybe this will be worth a lot one day type thing, right? But I think if you really talk to collectors, they also know that 99.5% of this is either going to be worth what it's worth when you bought it or less in the future, So I don't know that there's a real expectation of profits with that in the same way that there might be when you were playing in the stock market or, and are doing it, buying and selling a company or, things like that. But then your question about, can a third party run with it and make it sort of turn it into a security, so to speak. I guess maybe possibly depending on what they do. I mean, I guess if this third party then takes that asset and, I don't know, tries to promote it and advance, which happens in the art world too, right? I mean, people will be like, oh yeah, now I've got this great body of work. I'm going to have my gallery show is going to be all this show of this one artist who is reaching new heights. And this, you better buy now because in 5 years it's going to be unattainable and going to be selling at auction for millions of dollars and all this stuff. It happens, right? Those stories are told and those transactions happen. They just are not regulated in the same way. I think the securities are in the art. Like, why isn't a $1 million painting regulated in the same way that other securities are regulated? I think that is a conversation that's been happening for decades, even before any of this web 1, web 2, or web 3 ever happened, and I don't know, I'm sure there are probably securities lawyers who are still studying this issue that could give you probably a better answer. But my sense is that, those NFTs that are really treated as collectibles and people are collecting them as collectibles, right? I don't think they're going to be regulated.
Vivek, you mentioned briefly a little bit earlier royalties and things, and it is now possible to fractionalize music and buy royalties on different platforms. Can you talk a little bit more about that? That's just such an innovative application of Web3.
Yeah, no, absolutely. And actually, we've had the pleasure of working for a long time, almost really from the beginning, with Royal.io. Which is, like, as you note, I think correctly, a really innovative startup. Those guys, Blau and the other founders, I think, and the team really have, I think, like, taken something that seemed almost like non-disruptable, right? And really figured out a way to engage the audiences in, like, a really meaningful way, And what I think is so interesting about, there's so many interesting things about this specific space and Royal.io in general, but what's interesting there is, it's not even, it just shows, right, that, like, not everything can be, like, logically scaled and hacked and funded. And, like, we can't really look at everything as like an economic mathematical model to be solved. There still is, like, these very soft human, like, emotional components to engaging with the world, right? And I think with Royal.io, people are always surprised when they see, fans are not making millions of dollars off of, like, owning a fraction of, like, a Nas track or a Chainsmokers track, right?
Right.
But they are feeling some very, very deep connection. And I'm just going to be honest, and if the guys from Royal hear this, like, hopefully they don't mind. But when they first came to us, I remember, I'm a huge music fan and have been my whole life. I've played music my whole life. I'm always listening to music, and I was very into it when we got introduced to them. And I gotta say, I wasn't quite sure about it, right? I was like, is this really gonna, how's this gonna work? And I was proven completely wrong. And it's because I think I didn't even listen to my own self, right, with my own sort of soul when it comes to, like, the importance of connecting with music, right? And these fans, just by engaging in that transaction or whatever, it brings them closer, it brings them in, and then with all the non sort of economic benefits you can get from participating in this royal experiment, so to speak, right, is really cool, right? And I think that they have taken the first big step to what, many others have tried and are still trying, and I think very sort of admirably, like Spotify and SoundCloud and the others, to try to really how do we engage our fans in this digital world now with music, right? And I think that they have done an outstanding job. There's another startup that we're working with that I love called Sona Stream, and they're also doing really interesting things with allowing fans to, essentially invest in a track, right? And they've gamified it to allow participants to essentially earn cryptocurrency rewards, benefits, depending on the performance of that track, right? It just out there in the world. So, I think I'm glad you asked me that, because I think, music has been an area, and long before even streaming. I mean, it's just been an area that has been really used by everybody, but really made and managed by a few. So
and profited
it's cool to see
by a few.
Yeah, profited by a few. So it's really great to see a lot of these technologies moving forward. And I don't think that it's surprising that we are at the same time, I think in part as a result of this, seeing so many more women and musicians of color sort of ruling the charts and the airwaves and like getting the attention. And I think that's awesome.
Man, this has been pretty refreshing. Most of the lawyers that I have to engage with for, our clients, I end up spending a lot of time educating about the technology that we are actually advising on, right? Like tokenization and digital assets, and what does that mean and how could that apply to securities? So it's really refreshing to hear, from a lawyer that is actually, in this space and understands the applicability and understands the underlying frameworks of these technology capabilities that are coming to market here. I mean,
let me say something on that one point. I just want to say something on that one point because I get that a lot and I hear that a lot, right? And there's probably at least one law student or lawyer, young lawyer that's listening to this. And, I really want to say this, and I feel like it's a bit of an obligation too, to like, just from a professional standpoint, like the thing about law and what makes it so unique is that it literally touches every corner of modern life, right? So if you are just into cars, or if you are into books, or if you are into computers, or you're into blockchain, or you're into art, or you're into sports, right? Or you're into numbers, or whatever you are into, there is a legal job for you. And I think that law schools, with all due respect, do a horrible job of teaching that to our young lawyers. And so then what ends up happening is everybody gets out into practice. They just take the first job or the highest paying job that comes to them. And then they end up on this track. And then they end up, oftentimes, not always, but oftentimes in a place where, they're not really happy. And I think that has contributed to a lot of the sort of, unhappiness and sort of the mental health crisis that we see in the legal industry, right? And we have for decades. So I'm glad you said that, because I would just say to any young person out there who is thinking about using the law as a tool to, as part of their career, find out or just ask yourself what you're passionate about and what you love. And I guarantee you there will be a job that piggybacks off of that. And for me, I've always been interested in new technologies and anything related to art and music and film and these things, right? So I just kind of like took a mishmash of everything I was passionate about and put it all together and like tried to build a company around it.
Man, that's awesome. I think that's a great way to end this episode here. I mean, again, it's just really refreshing, and I think you hit the nail on the head. And I think this could be applied to almost any industry, especially when you think of your traditional, corporate, white collar job. There is always room to find an intersection between your passions and your hobbies and how you could turn that into your professional career or make it work into even consulting, right? I didn't, before this, I was doing M&A and, traditional business strategy. And now here I am talking every day with DGens and with people like Sue that are really pushing, the industry and really thinking about how do you promote industries even further and further and further with these net new capabilities. And it's just awesome to see that there is a subsection, within law, which, traditionally is the one that lags behind. We have so many of these innovators pushing through all these new capabilities. And, we're all waiting for what is the regulatory compliance? What do I need to adhere to make sure that I remain legal, right? Well, who do I engage with? Well, if there's no established precedent, well, maybe we have to be the ones that kind of pave that path forward. And I think it takes young minds, especially who are natively and much more organically in tune with these technologies because they're using it in their daily lives as a habitual nature, to really think strategically about how it's applied from a legal context. Because I think what we're seeing right now, and especially, with a lot of these recent talks in front of Congress and Senate, is the old guard, so to speak, doesn't really have an ability to understand the concepts that they need to be, enacting the laws around, right? And it takes that younger audience, the people that you are hiring, right? The people that are being onboarded into your firm and the people that you're talking about in law school to really, hey, I love this concept of NFTs. I love this concept of digital assets. I love this concept of tokenized securities. Let's go see how we can adapt, current statutes to make sure that these remain compliant so that we can then, pave a safe path forward for everyone.
Yeah, no, I agree. I agree with everything you just said there, Shiva. I mean, I've always been, and maybe it's something that I got from my father, who turns 80 in a couple of weeks. He always, even when we were younger, he's an engineer, and he's been very entrepreneurial. But there's been stints where he's had like jobs in like engineering firms, and he's always hanging out with the kids who just graduated from engineering school. Even when he's in his 60s or his 70s, like that's who he's hanging out with. And I've always also surrounded myself by a lot of young people because I feel very energized by them. I teach, a couple courses every year at the University of Miami Law School, which is, I love doing, in part because it puts me front and center among, the youth, the next generation. And I learn a lot from my children who are only 12 and 6. But when I see them on Roblox or playing Minecraft or whatever they're doing, like I'm interested. And I can't really explain it. But I do think that sort of openness and approach would do a lot of folks in Congress really well, because, I know even at 44, I don't have the capacity to know everything anymore. And so if I want to understand something on Discord or what's happening on chain, I oftentimes do turn to a few people at my firm who are like right in it 8 nights a week, like, really engaging. And so I think like, that's really, a great, way to kind of, learn these things. And the other thing is, when a lot of us who are like adults or whatever, or older and, been doing things for decades now, like the younger people, they want to engage with you in this way. Like they want to share their experience with you. What I have found, at least in the legal industry, is that is just like, it's just not something that the older guard necessarily is like seeking out.
Yeah.
And I think that's a really missed opportunity.
Yeah. Yep. Yep.
Awesome. Well, another great episode, and I think we made this less dry than what people would think about trademark and law and Web3, and this was pretty fun dialogue. So thank you, Vivek, for giving us some time. It's not every day that you get a free 1 hour with a lawyer here, so hopefully we don't get billed for this. But I will always take an hour of a lawyer's time to talk about things like this. And thank you again, Sue, for being a tremendous
so much.
co-host here. Awesome.
Thank you so much.
Thank you, yWhales, for listening, and you all take care.